Hello everyone. Welcome to Sakshi Education. My name is Archana. I am your educator for Indian Constitution or Indian Polity. Today we are going to discuss about the next segment. In the previous video, we discussed about Article 12, 13 and 14. However, there were concerns that they couldn't hear, so I want to repeat Article 14 again because Article 14 is very, very important for your preparation part. So I just want to make sure that Article 14 is repeated again. So today I am going to repeat Article 14 as well as Article 15 for those who have missed or those who could really, those who couldn't understand. I make sure that you can understand now. If you are not able to hear now also, you can just leave me a message whether I am able to, whether you are able to listen to my voice or not, so that I can proceed with the class. Okay, so I would like to start it off. So in the last video, we discussed Article 14, though we have discussed, it would be a repeated one. Yes, we will be repeating this again. As there are many case studies, there is a need for us to discuss this again, or else I would have, we would have continued with the 15th article. But since we do have so many case studies, I would like to go ahead again with Article 14. So today we are going to discuss about Article 14, that is equality before law and equal protection of law. And equal protection of law. If you are not able to hear my voice, please leave me a message in the live chat so that I can see. I would know whether you are able to hear it or not. You can leave me a message over there. Okay. Yeah. So Article 14 is talking about equality before law and equal protection of law. This concept of Article 14 to 18, is a right to equality, and this equality before law is being taken from UK, and equal protection of law is borrowed from United States. It is known point. And the main objective of Article 14, when I say it is equality, what kind of equality are we going to ensure? We are going to ensure political, economic, and as well as social equality. We need to ensure political, economical, and social equality as well under Article 14. Right? Now, this equality before law, we have to know that equality before law is being taken from United Kingdom. It is based on APPSC concept called as rule of law. So it is being borrowed from APPSC concept called as rule of law. Now, when we say equality of persons, what do you mean by this equality? What kind of an equality? Right? What kind of an equality? How you are going to ensure equality is the main features. The main features of Article 14 are, the first and foremost thing is equality of persons within India means absence of any privilege. When I say equality, you have to answer. You need to understand that there wouldn't be any privilege. This statement is mentioned by Supreme Court in the case Amita versus Union of India 2005. In this particular case, Supreme Court stated that equality means no privilege. Equality means absence of special privileges to any individual. However, when I say equality, you cannot expect absolute equality is never possible. When I say absolute equality, it means 100% equality is never possible. Please remove from this from your brain that you will be getting absolute equality. No, it is not at all possible. Somewhere down the line, you will not see 100% equality. You have to understand this fact. You have to realize this fact, and you have to go on with the you have to go on with the administration. See, it is not my statement. Even many philosophers, many political philosophers, they have emphasis to that at 100% equality, 100% secularism, 100% sovereignty, 100% socialism is available only in an ideal state. Ideal means a very noble state, but you will not find a noble state anywhere in the world. It is all, and it is a benchmark we have, but reaching to that benchmark is not possible. So 100% equality cannot be assured anywhere. Not 100 equality, it can be anything. Absolute equality cannot be assured. Absolute treatment cannot be assured. Absolute secularism is not assured. So why I'm highlighting this point is, many youngsters or many students or aspirants, when they come across any injustice, immediately they will say that why they have to do like this. See, please understand, there are practical scenarios, you will have practical situations, because everything cannot be done by the government. Even the people also should have the will, to get out of their bad situations, and they need to stand. All this is a mutual thing. It is a combination of both the government as well as the people. So 100% equality is not at all possible. Example, I'll give you one best example. No one likes a small kid or a small boy or a girl begging on the streets. Like, in the senses, you feel very bad when you see someone begging on the streets. Now most of the people, they immediately say government is not taking any action. No, you cannot say that. Government will take action, but the boy or girl parent also should have that that willpower, that they should not send their kids for begging and all. They Unless and until they don't have that willpower, it is not possible for the government to eradicate 100%, right? Many a times, have come across many kids begging on the streets. I called up 1098 for the child care many times, and we informed them that there are so many kids over this area, please take care of them, they are begging, and we are ready to send them to schools. But no, they are not at all ready to go to the schools. So tell me, is it that I can make them 100% to go to the school? It is not possible. They also should have that key. I need to go for school, I have to study. So why I'm telling you is, this point is very, very important, that the practically absolute equality or absolute secularism is nowhere possible, right? Please keep this in mind, and you have to go ahead. Then for you, the things will not turn complex, or you will not see things negative, or you will not write answers negative. This is what I'm trying to say. And also, when I say equality, it guarantees it similar treatment. It guarantees similar treatment, but not identical treatment. But not identical treatment. But not identical treatment. Okay. And in a case called as Ashutosh Gupta versus State of Rajasthan 2002. In this particular case, it is mentioned that the legislative classification need not be scientifically or logically perfect. As I told you, absolute is not possible. So the legislative clarification need not be 100% or scientifically or logically correct. This is being stated in Ashutosh Gupta versus State of Rajasthan. Next step. Right. In Glen Rock Estate Private Limited versus State of Tamil Nadu. In this particular case, 2010, it is mentioned that a person would be treated, a person would be treated unequally only if that person was treated worse than others, and those others must be similarly situated. Okay, see, unequally, if he is not treated properly only, then he would be treated unequally. This is being stated in Glandorf. This is not so important because it's a it's an interpretation of equality. And also, this is very important case in TMA Pi Foundation. In TMA Pi Foundation versus Karnataka case 2002, very important, because in this particular case it is mentioned that conferment of special benefits or protection of rights to particular group of citizens for rational means, for rational reasons, is called as equality. It's called as equality according to Article 14. So if you are trying to place a particular group above others, let's suppose there are some weak sections in the society, and the government is taking initiatives in the name of reservations to lift them up and make them equal, okay, with others, then such upliftment or then such reservations also will be called as equality according to Article 14, right? So it should not be like for everyone. It should be for special groups like who are being considered as backward, and for them special benefits are required. Yes, whatever the measures are taken by the government, they will be considered as equality under Article 14. Let's suppose, assume that now. Assume we have third gender now. Third gender is not being accepted in the society so freely or easily like a male and a female. Now, to uplift this third genders and to give them equal chances, equivalent to male and female, whatever the initiatives are taken by the government to uplift this transgender should be treated as equality according to Article 14, because they are a special group and they are being undergoing so many atrocities, and they are not having any access to political equality, social equality and economical equality to ensure that properly on par with the other groups of the society. Whatever the steps are being taken by the government, they would be considered as equality according to Article 14, right? So this is one of the best examples. You can see now, as I mentioned to some of my students, you can see now there is a change in the applications. All the applications are asking for your gender. They included a new gender called as others. They are not only looking for male, female, they are even looking out for the other gender or third gender. That itself is a welcome move, and whatever, when an application is opened for a third gender, it means that they are ensuring equality, right? In Tamil Nadu, a female who is a transgender, she is being given an opportunity. She is made as a police. That itself is a step forward. That itself is a step towards ensuring equality, right? So it is also called as equality. Is not a violation. It is in fact supporting or executing Article 14. Okay. Now the next one is in Satimbala Sharma, versus State Call Senior Secondary School. This is also important. Secondary School, case 2011. It is mentioned that right to equality under Article 14 is available against state and cannot be claimed against unaided private minority school. So this equality is available only in relation with the government. You cannot expect equality from unaided private schools. Okay, so the private schools, especially the unaided, means they are not dependent on government for any funds or financial support. Such kind of private minority schools, they need not show you that equality, they can discriminate. Okay, this is what is being highlighted by Supreme Court in this particular case as well. Now, I have a doubt. Now, what do you mean by equality? Equality before law. When I say equality before law, it can be prime minister, it can be president, it can be chief minister or governor, anyone. It can be you or me. All should be treated equally before law. When I say equally before law, in the census, you should not have any special privileges to prime ministers, presidents, etc. Now, is it correct? A prime minister, can he be called for a court to a court for an inquiry? No, you cannot. That is the reason you have certain exceptions for Article 14 part, that is equality before law is having certain exceptions. So please understand that me, you, Prime Minister, Chief Minister, everyone will be called to the court, but we do have certain limitations. When they are in their power, when they are in their positions, when they are in the post of president, governor, and prime minister or CM or whatever, they cannot be called to the court. Once they are out of those positions, you can call them, you can treat them equally like others. Once they are out of their position, you cannot give any special privileges to them. This is what you have to understand. Now, what are those exceptions? What are those exceptions? Let's see those exceptions. Exceptions to Article 14 is especially equality before law. We are discussing about, we know that Article 14 is two concepts, that is equality before law and equal protection of law. We are talking about exceptions to this part, equality before law. What is that exceptions? Whenever a president or governor are in their office, and while performing their office, whatever powers, performance or duties of their office are being conducted, whatever they are done, their powers, as long as they are in the positions of president, governor, okay, the duties or performance, whatever are being there, they are not open. They are not open to courts, or they are not open for judicial review. Means the president and governor, while performing their powers, while they are performing a task, or while they are executing their duties or responsibilities, those duties and responsibilities cannot be open to the court. They are not subjected to judicial review. This is the first exception. Second exception is, you cannot initiate, no criminal proceedings can be initiated. Okay, no criminal proceedings can be initiated against a president or governor during term of office, as long as they are in their position, as long as they are the presidents and governors, you cannot initiate a criminal proceeding. You cannot initiate any criminal proceeding against them. Now here I would like to mention one, while getting to one live example. We had a coal scam happen in 2012 when our ex Prime Minister Mr. Manmohan Singh was there. Now, since he was the leader of the party at that time, since he was the leader of party in the sense, since he is the leader of his ministers, he is a gang leader for his council of ministers. One of his ministers has committed the coal scam. Now, he was not called for any of the enquiries as long as he was there as a prime minister. Once he stepped down as a prime minister, and once he became the MP, he was an MP only, right? So once he stepped down as a prime minister, he was called before the CBI for inquiry. He was called for CBI inquiry. They have done questions. They have inquired. They asked him. They have done interrogation for so many hours. Though he was an ex prime minister. Now here you have to understand that the equality before law is being executed because as long as he is prime minister, you cannot. But once he's out of a prime minister position, he was treated equal with the other common people, and that is where Article 14 is not violated and it is being executed. This is what you have to understand. However, there are certain exceptions. There are certain exceptions which cannot be, barred. I mean, these exceptions cannot bar. Okay, what are those exceptions? Okay, so the exceptions, whatever the exceptions I have mentioned, those exceptions shall not bar impeachment proceedings, means they will not stop any impeachment proceedings against president, and also they will not stop or bar any suits, appropriate proceedings against state or government. Okay, any other appropriate proceedings will not be stopped, and the exceptions are not valid in this particular case. Okay, now let's see the second part of Article 14, which is nothing but equal protection of law. What do you mean by equal protection of law? We are seeing the second part of Article 14, that is equal protection of law. This is borrowed from United States. Okay, what do you mean by equal protection of law is among equals, law should be equal and equally administered. Law should be equal and should be equally administered. Let's suppose A, B, C, D are four equal people. So these are four equals. Among them, whatever, let's suppose all these four committed murder. Okay, murder with intention, with cruel intention. Means the output is murder, and the reason for that murder is cruel intention, it is same. So A, B, C, D, they committed murder with cruel intention, means the situation is same. Since the situation is same, they should be treated equally. The law should be treated equally. The law should be executed equally for all these four. This is what is called as equal protection of law. Okay, I'll give you one more example. I explained in the last class, but still I will explain it very fast. There is a person called as A. Now this A, it's a female. Okay, the female A killed B. Okay, and there is another female called as P. Okay, she is a female. Let's suppose she killed Q. Now A killed B because B was actually harassing A, and B was about to kill A. So as process of protecting herself, self-defense, as process of protecting herself from B, A killed B. Okay, the output of this event is death only. The output of this event is death only. So A killed B because B was about to kill A, and in order to protect herself, A killed B. So it is self-defense. The output is death. Now here in P and Q case, the output is same, the death, and P killed Q. But P killed Q because P don't want to. P is, let us suppose, is having extramarital affair. He is having extramarital affair with the person called as X. So in order to have relation with X, let's suppose P killed Q. Now this condition and this condition is different. Please understand. Here A and P are females only. B and Q are male only. The output is death. But A killed B because to protect herself, self-defense. But P killed Q because she is having an extramarital affair with X. So this condition, the reason why they have killed is not same. Since the reason they have killed is not same, you cannot treat well A. You cannot, in this condition, you cannot treat A equal to P. Now, if you treat A equally with P, then you can say Article 14 is violated. As long as A is not treated equally with P, it means that equality is there because A's condition is different and P's condition is different. This is what is called as equal protection of law. Okay. Now, let's see what are the various cases with related to Article 14. Now, while providing equal protection, by state can be affirmative. State can be affirmative. How state will be affirmative is by providing facilities and opportunities to unequals. So, government, while ensuring equal protection before law, the government can be affirmative. How it can be affirmative is, it can be affirmative by providing equal facilities and opportunities to unequals. Now, this particular statement of providing equal opportunities to unequals is being interpreted in a case called as Hari Bai versus Panchayat Varg Cooperative Society in the year 1996. In this particular case, it is being interpreted equal protection of by state means by state giving equal opportunities facilities to unequals. And in Rakesh Kumar versus Union of India case 2010, state can treat unequals differently by equal playing in social, economical and political spheres. Means in Rakesh Kumar versus Union of India case, in this particular case, equality was considered as ensuring equality both in social, economic and political angles. Just a minute. Next, in Anwar Ali versus Bengal State, 1952, in this particular case, equal treatment in similar situations, to be ensured. When I say discrimination, positive discrimination, which gives advantage over others. Means the weaker sections of the society, whatever the special treatment is given by the government to these weaker sections, even though there seems to be unequal, such kind of discriminations are called as positive discriminations, and such positive discrimination cannot be called as a violator of Article 14. Instead, you can call this as in favor of Article 14. Okay. Next. In Kamala Palace versus Union of India case 2 is about Article 14. Now let's see Article 15. So put the heading Article 15. Article 15. It prohibits discrimination among people. The main objective of Article 14 is prohibiting discrimination among people. Now the question is, by who? By whom? Okay, by whom you need to prohibit? It can be either state, means you need to prohibit the discrimination among the people by the state, and you should discriminate among the people, the discrimination by the other individuals. Means you should stop government discrimination. I mean, Article 14 prohibits government discriminating the people, and Article 15 prohibits government discriminating people, and the same Article 15 also prohibits discrimination by the people among the other people, individuals over other individuals. Now let's see each and every clause in this. Article 15 clause 1. According to Article 15 clause 1, state cannot discriminate people only, please understand, only on grounds of caste, religion, race, place of birth, sex, etc. Means, according to Article 15 clause 1, state cannot discriminate people on basis of caste, religion, race, place of birth, sex, and etc. Means, try to understand that state can discriminate people beyond these factors. Means, state cannot discriminate people based on these 5 grounds only. But state can discriminate people based on other grounds. That is the reason the point only is very, very important. Means state cannot discriminate people based on these five parameters. But beyond these 5 parameters, whatever is there, state can discriminate. State can discriminate, and it cannot be called as violative of Article 15. Again, I repeat, state government cannot discriminate people on based on this 5 factors only, but government can discriminate people beyond these 5 factors. And when government is doing such discrimination, you cannot call it as a violative of Article 15. Now this point is being mentioned by the government in or High Court in Arvind Ramakant versus Kerala State 1999. In this particular case, it is mentioned that any other discrimination not mentioned in Article 15 clause 1 is not unconstitutional. Is not unconstitutional. Right? So If government is treating two different caste people separately, yes, then it is a violation. Beyond caste, religion, race, place of birth, and sex, any other discrimination, you cannot call it as unconstitutional. This is not my word. It is being mentioned in Aravind Ramakant versus Kerala State 1999. And in Ashok Kumar versus State of Madhya Pradesh, case 2010, discriminating in favor of men, discriminating in favor of men on the ground of sex alone is not permissible under article or according to article 15 clause 1. However, means whatever favors you are trying to do for men, or if you are discriminating men over women, or if you are treating men separately, or if you are providing anything in favor of men, then it will be definitely called as unconstitutional, which is being highlighted in Ashok Kumar versus State of MP 2010. Very unfortunate. I'm really very sorry. This is discriminating men and women. So, but Constitution itself speaks that in the see many males, they say that law is not in favor of them. Yes, to some extent, as I told you, 100% absolute equality is not ensured. This particular case is the best example. Ashok Kumar versus State of MP 2010. In this particular case, it is highlighted that whatever you do in favor of men based on the ground of sex, it is unconstitutional. It is not at all valid. But now see the twist. See the twist now. Any discrimination in favor of women. This is where our power comes in favor of women is permissible, is allowed according to Article 15 Clause 3. Okay. So 15 Clause 1, discrimination of men is not allowed. But according to 15 Clause 3, government can make laws, government can make legislations or GOs in favor of women. And if they are made in favor of women, please, you cannot call it as unconstitutional, because it is being mentioned in the Constitution under Article 15.3 that the government can make protective measures in favor of women and children. Means government is having the power to treat women and children special treatment. They can do the special treatment, right? Again, this is not my statement, please. It is government statement. Okay. Now this 2 points are the main highlights of Ashok Kumar versus State of MP 2010. Right. Now we have another. We will see Article 15 Clause 2 now. Article 15 Clause 2. A citizen cannot discriminate another citizen for entering into public places. Okay, a citizen cannot discriminate another citizen for entering into public places. Okay, means I cannot stop another person in entering into public places. When I say public places, it can be gardens, public wells, cremation centers, grounds, temples, public properties like police stations, railway stations, You cannot stop. Okay, under Article 15, Clause 2. However, please understand, under Article 15, Clause 1 and Clause 15, we need to understand that discrimination is allowed. We can allow discrimination. This is the exception. This is the exception. Means discrimination is allowed only on grounds of public health. Now COVID, if your neighbor is not allowing you to come inside, it is nothing wrong. Please, you cannot go to the police station and file a case saying that my neighbor is not allowing me to enter into their house. Please, your neighbor is having the right to discriminate on the ground of what? Public health. And that too, it is being issued by the government. Please understand, government has given the guidelines. So government is having the power to discriminate on the grounds of public health and public moral and public order. For example, we won't allow the prostitutes to reside among the general communities or the general family areas or residential areas. Why? It's because, yeah, they are paying rent, they do also pay rent, they are like us only, they are also part of India. Yeah, everything is accepted. But keeping in mind the public moral, the society's values and all, the government is having the power to restrict their movements also. Okay. And to control law and order, the best example for this is Section 144. You see government sometimes imposing Section 144 where they will be restricting your movement and my movement. Yes, the government can do. You cannot call it as discrimination. It is allowed because it is the responsibility of the government to protect the law and order. So in order to protect that law and order, the government can discriminate. The government, in order to protect the public health, it can discriminate. The government, in order to protect the public moral and values, it can discriminate. So you cannot call these as violative of Article 15, Clause 1 and Clause 2. This is what you have to understand. However, we do have certain exceptions. What are those exceptions? Like how we had exceptions to Article 14, we do have exceptions even to Article 15. What are those exceptions? Let's see. Exceptions to Article 15. Article 15, Clause 3. Okay. Now, this particular Article 15, Clause 3, under this, state can provide special provisions for the development of women and children. Now you need to understand why the laws are in favor of girls, women. It's because we are being given power constitutionally itself. Article 15, Clause 3. Okay, right? And in how can you say this is, see, earlier, Section 497 of IPC, which is about adultery. Okay, adultery is extramarital affair. So, according to Section 497, adultery is punishable. It's punishable. But for whom? Only for men. Women will not be punished. Women will not be punished even they commit adultery according to Section 497. It was earlier. But now, on a whole, the adultery punishable for men, that clause is removed for both men and women. Okay. But earlier, women were not punished under adultery because it is understood that women need special provisions to protect her. That is the reason, since we need to, keeping in mind in India, keeping in mind the women status, keeping in mind the women's status or women position in Indian society, there is a responsibility on the government's shoulder to provide extra to provide special protection to women. That is the reason they didn't made adultery punishable for women. Instead, they have restricted adultery as punishable only for men. I'm talking about earlier, but now adultery is not punishable for both men and women. Okay, and this point that adultery is not punishable for women is not punishable for women is being highlighted in the case called as Aravind Ramakant versus Kerala 1999. In this particular case, it is being highlighted that adultery committed by women is not punishable. Okay, why? Because in Indian society, the women's status needs special immunity, special protection, and so they didn't make it punishable. Right? Now let's see the next exception. What is the next exception? Article 15, Clause 4. This is being incorporated by First Constitutional Amendment Act 1951. And according to this, state can provide special provisions for educationally and socially backward classes, backward communities, sorry, educationally and backward communities, educationally and socially backward communities. According to this only, state can reserve seats to BC, SC and ST plus fee concessions given in public educational institutions. Public educational institutions. This is being highlighted. This is being interpreted in case called as Chitralekha versus Mysore State 1964. In this particular case, it is being highlighted that the government is having the power to reserve states to BC, SC, ST, and also fee concessions can be given in public educational institutions. Now, next. The next case study which I am going to say is very interesting, and I am sure that you will not find out this point in any other class. You have to, I'm sure, because even when I studied, this was not mentioned to us. This point is very, 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 very important. Let me highlight it. Please keep a star mark for this point, for this particular case. In Gulshan Prakash versus State of Haryana, 2010. In this particular case, it is highlighted that Article 15, Clause 4 does not make mandatory provisions for reservations. Means there is no such mandatory provision for reservation as mentioned under Article 15 Clause 4. Means Article 15 Clause 4 is saying that state can provide. When I say can provide, it means that it can give or it may not give. And I mean, it can provide reservation or it need not provide reservation also. Means government can give reservation and government is having the power not to give reservation also. It is being mentioned under Article 15 Clause 4 because in the Constitution it is not mentioned as must. Please understand, in 15 Clause 4 it is not mentioned that the state must give reservation. It is mentioned that state can give reservation. When you use the word can, it can be, it is 50-50%. In the sense, reservation can be given, reservation need not be given. There are two chances. So this particular interpretation was done in Gulshan Prakash versus State of Haryana case, that Article 15 Clause 4 does not make mandatory provision for the reservation, and the power to make reservation is discretionary. This one word is itself enough. This one statement itself is enough that the reservations are not compulsory. The reservations are optional. The government is having that power of being optional, and you cannot issue, no writ can be issued to affect reservation. No writ can be issued to affect the reservation. This is what is mentioned in Gulshan Prakash versus State of Haryana 2010. So please understand that the government's power to issue reservation is discretionary, and it is nowhere mentioned in Constitution as compulsory or mandatory. Right? Now, in Preeti Srivastav versus State of MP 1999. In this particular case, Article 15 Clause 4 highlights that compensatory or protective discrimination, whatever the discrimination we are talking, this protective discrimination should be reasonable and consistent with public interest. So whatever reservations are being ensured under Article 15 Clause 4, they need to be reasonable, and they should be consistent with the public interest. Means you cannot do something which is not supporting the public. It is not in line with the public interest. Whatever is in favor of the public interest, that only need to be taken into consideration. That kind of discrimination is only allowed under Article 15 Clause 4. This has been highlighted by the government in Preeti Srivastava versus State of MP 1999 case. Now, in KL, in KL Narsimam versus PG of Medical Education 1997 highlighted that SC/ST candidates, this is also very important, SC/ST candidates selected for admission to a course, it is mentioned as to a course, not only to medical education, to a course on basis of merit can't be treated as a reserved candidate. So those people, the SC/ST candidates who are being selected on basis of merit cannot be called as a reserved candidate. Okay. And also in this particular case, it is highlighted that reservation for admission to the specialty courses or super specialty courses in PG or doctoral course in medicine is permissible. The sense is SC/ST reservation is allowed in PG medical entrances or doctoral courses. Next, the last article, the last clause. Article 15, clause 5, which is incorporated by 93rd Constitutional Amendment Act 2005. This particular case, in this particular article, it is highlighted that reservation for socially and educationally backward communities, means reservation for socially and educationally backward communities in state or state aided. When I say state, means that respect to states also. State aided educational institutions. Means Article 15 clause 5 ensures reservation of seats for socially and educationally backward communities in state or state aided educational institutions. And it also highlights that when I say educationally and socially backward, you need to exclude the creamy layer. Means those people who are having government jobs, BCs. In backward classes also, some of them they do have government jobs at the state government or central government. Those kind of people will not be given reservation. They will be treated as general category. So you are, according to Article 15 clause 5, you need to remove such creamy layer OBCs, and the rest OBCs are being given reservation in the state colleges or state aided educational institutions. Okay, and however, this 15.5 is not is being available for private unaided institutions or not. This also was challenged in Ashok Kumar versus Union of India case 2005. So this is what is about the 5 clauses of Article 15, that is 15 clause 1, where we will say that state cannot discriminate people on the grounds only on the grounds of caste, religion, race, place of birth, and any other discrimination beyond this are allowed. And usually the state can discriminate people on the grounds of public health, public moral, and public order. And according to Article 15 clause 2, a citizen cannot discriminate other citizen from entering into public places. See, this happened in the olden days. The backward sections of the society, the Harijans, they were not allowed to use public wells. They were not allowed into temples, etc. These kind of situations were there, and that's the reason they have mentioned it. They have highlighted it under Article 15 clause 2. And also we have Article 15 clause 3, which is an exception to Article 15, which talks that government is having the power to provide provisions for the development of women and children. And also 15 clause 4, which was added in the Constitution by first Constitutional Amendment Act 1951, highlights that state can provide special provisions for educationally and socially backward communities. And the last one is Article 15 clause 5, reservation for socially and educationally backward communities in state and state educational institutions, excluding the creamy layer. And this Article 15 clause 5 is not available for minority educational institutions, means you cannot demand reservation for the socially and educationally backward classes in minority educational institutions. So it's not so complicated. You may see repetition of words. It is all connected. It is more of like logical. If you understand if you just connect to the logic, you will be able to remember it very easily. You have to focus only on the case names because sometimes it is hard to remember. But rest-wise, it is very easy. Just to understand the interpretations, like how the cases are for our understanding. To interpret Article 14, 15, like how you are going to interpret what do you mean by Article 15, what do you mean by Article 14. This is being interpreted by the courts in various cases. That is what we are trying to understand. Without mentioning the cases, if I say that minority educational institutions are not included, if I say that, you'll not be able to understand. So the cases are for you to understand that in this particular case, this meaning is derived. Okay. So that's all for today. With this, we have covered Article 14 and 15. In the next class, we will be discussing about Article 16, 17, and 18. I'm taking it off very slow because fundamental rights are very, 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 very important. I don't want to rush. I want to make it slow and make you to understand. Once fundamental rights are completed, the directive principles of state policy, fundamental duties are very easy and you can cover it very fast. This is the place. This is the point. Fundamental rights, we need to go slow. There is nothing wrong of learning, 2 or 3 articles in a day. There is nothing wrong in knowing it. Right? That's all for today. And if you have any queries, please, you can follow my Instagram page or you can ping me. I'll be happy helping you out. Thank you so much for giving me this opportunity. Jai Hind.